many universities, I learned from youngsters like you, why such and such thing is there in the Constitution, why it can't be done like this. Maybe there is a difference between the kind of thought which you have because you are the beginner, and maybe some difference on my thought because of the practical experience which I have acquired during my tenure while working with the government or while practicing law or interacting with the society. And it is that experience which I have acquired I'm trying to share with you. But when we are talking of the socio-legal cultural issue, I think the tone was set in the inaugural session of the symposium when many issues were highlighted. If we are talking about the constitutional issues which arise from the Constitution and the provision is made in the Constitution, some of the issues about which we are concerned as on today are the people's safety. And when I'm talking of the people's safety, I'm talking about the interest or the rights of the vulnerable group of the society, including the elderly people, including women, including children. And when I'm talking of women, women of those sections who cannot protect their own interest. I know since 1950 there has been change, but that change is not as appreciable as we expected it to be. Today, we can boast of this thing, that we have professors, we have politicians, we have ministers, we have governors, and we have the president who belong to that particular strata of the society. But at the same time, there is a large number of people who are not even about of what their fundamental rights is, what preamble of the Constitution is. And to draw your attention to this particular aspect, I don't know how many of you have seen that video. On 26th of November, when we were celebrating our Constitution Day, there was a function in the Vigyan Bhavan organized by the Supreme Court, where all the judges of the Supreme Court, High Court, district judges were present, and the President in India was addressing the judges. Now, in spite of the fact that you have made provision on the Constitution and you have made laws to protect the interests of the weaker sections of the society, as Professor Saurabh Chaturvedi was also mentioning, in spite of that, what is the state of affair of justice administration in our country? And when I'm talking of the vulnerable section, and this is coming from the mouths of the President of India. Can you please play that video? It's a video in which the President of India, being first citizen and head of the state, generally deliver a written text. But in this text, after reading the written text for about 10 minutes, she spoke extempore. And what she said is coming from her heart. And I want all of you to listen it. If you really want to be a successful, good advocate or practitioner and really want to protect right of the downtrodden people, listen to what the President of India has to say. Can you?
कि मैं जो आप सब जानते हैं, मैं एक छोटी सी गांव से आई हूँ, जहाँ कोई भी ऐसी, मैं जब पैदा हुई थी, जन्म ली थी 1958 में, वहाँ कोई भी ऐसे सुविधा नहीं थी। गांव के लोग, हम ये 3 लोगों को भगवान मानते थे, टीचर, डॉक्टर और लॉयर्स। टीचर को ओडिया में एक प्रोवर्ब कहते हैं, गुरु को न मानिब नर गुरु ही न साक्षात ईश्वर। गुरु एक मनुष्य नहीं, ये साक्षात ईश्वर है। और डॉक्टर को भगवान मानते थे क्योंकि वो जीवनदाता है। डॉक्टर और लॉयर्स के पास कितने टाइम लोग जाते हैं जो अब परेशान में होते हैं, दुख में, परेशान में। जिंदगी या उनके पास जो भी हो, धन दौलत ज़मीन जो भी जायदाद देने के लिए तैयार हो जाते हैं कि हम लोग परेशान से थोड़ा पार करो। जो मैं एमएलए बनी तो भाग्य से मुझे होम स्टैंडिंग कमेटी का चेयरमैन बनाया गया। मुझे पूरा राज्य में जितने भी प्रिजन, जितने भी जेल था, मुझे घूमने को मौका मिला। ऐसे नहीं कि मुझे भेजा गया, मैं जानना चाहती थी वहाँ लोग कौन लोग वहाँ होते हैं, क्या करते हैं, क्या खाते हैं, कैसे जीते हैं, कैसे कैसे परेशानी में क्यों, क्या वो गुनाह किया, क्या क्राइम किया, क्यों यहाँ पड़े हैं। कोई 10 साल से, कोई 20 साल से, कोई 25 साल से, कोई 30 साल से जिंदगी वहाँ वो बिता रहे थे। आप सब जानते हैं स्टैंडिंग कमेटी का काम है रिपोर्ट देना। मैंने आके सभी होम डिपार्टमेंट के जितने भी ऑफिसर्स को मैं बुलाती थी, मीटिंग करती थी, डीजीपी को कहती थी, सीएम को जाके अपना जो भी अनुभव मैं बताती थी। थोड़ा बहुत कुछ हुआ, लेकिन जो मैं चाहती थी वो नहीं हो पाया। लेकिन भाग्य से मुझे गवर्नर बनाया गया। इसी तरह की ऐसे पीछे वाला स्टेट में, जैसे कि ओडिशा जैसे पीछे है, ऐसे ही मुझे झारखंड में बनाया गया, गवर्नर बनाया गया। मुझे एक मौका मिला कि सुप्रीम हाई कोर्ट जजों के साथ एक जज यहीं पे, हाई कोर्ट जज यहीं पे बैठे हैं, बॉस जी मैंने देख रही हूँ, 4-5 ऐसे चीफ जस्टिस के साथ मुझे काम करने का, वार्ता करने का मुझे मौका मिला। वीरेंद्र सिंह मुझे तो शपथ दिलाए थे, उनसे भी मैं बात की, लेकिन वो ज़्यादा दिन उनका हो गया टेन्योर, तो मेरे साथ नहीं काम किया। लेकिन 2-3 इनके साथ भी बात की, लेकिन ये भी ज़्यादा दिन नहीं, वो तो यहाँ आ गए। लेकिन ऐसे 2 सुप्रीम कोर्ट जज, एक है पीके महांती और एक है डीएन पटेल। डीएन पटेल तो सुप्रीम कोर्ट की जज तो, हाई कोर्ट की ये तो जज तो नहीं बन पाई ये है, तो फिर इंचार्ज थे। लेकिन वो बहुत ही, उनको मैं अप्रिशिएट करना चाहूँगी। मुझे पता नहीं आपका क्या ख्याल है, मुझे तो उनके ऊपर बहुत अच्छा ख्याल है। मैं अपनी बातें मैंने कहने लगी, तो क्योंकि मैं थोड़ा उनके लिए कुछ करना चाहिए आप लोगों को, क्योंकि कौन लोग हैं जेल में, कौन लोग हैं, ना उनको फंडामेंटल राइट्स के बारे में पता है, ना उनको प्रियम्बल के बारे में पता है, ना फंडामेंटल ड्यूटी के बारे में पता है। थोड़ा बहुत कुछ कर दिया, किसी को थप्पड़ मार दिया। आप जानते हैं वहाँ के लोग थोड़ा खाने पीने में, दूसरा चीज़ खाने पीने में माहिर होते हैं, है ना। थोड़ा बहुत कुछ ऐसे कर दिया, किसी को थप्पड़ मार दिया, क्या क्या दफा लगा दिया जो लगाना नहीं चाहिए, लेकिन वो सब क्योंकि आजकल ऐसे बहुत सारा होता है, तो ये सालों साल उनको छुड़ाते नहीं है। उसका कारण जो भी बचा कुचा है ना घर पे, जमीन जायदाद जो भी अपना यूटेंसिल वो ख़त्म हो जाएगा, इसीलिए जाते नहीं, छुड़ाते नहीं। मैंने बोली इनके लिए तो कुछ करना होगा, केवल सिविल जो लोग ये नहीं है। आप जानते हैं गवर्नर चांसलर होते हैं यूनिवर्सिटी का केसेस भी, ये जितने भी यूनिवर्सिटी का वाइस चांसलर, जितने प्रोफेसर कोर्ट का चक्कर लगाते रहते हैं, क्लास में टीचर नहीं होते, क्योंकि रोज चक्कर सालों साल, ये क्या हो रहा। तो मैंने बोली कुछ तो करना चाहिए। लेकिन मैं धन्यवाद देना चाहती हूँ, वहाँ तो अपना एक संस्था बनाया है झालसा, है ना, उसके जरिए वो एक दिन में ऐसे काम किए, दिन रात, एक दिन में वो शायद 5,000 होगा। एक बार पीके मिश्रा उन दिनों यहीं पे चीफ जस्टिस थे, उनको बुलाया गया, एक दिन में 5,000 केसेस वो ख़त्म कर दिए। सेकेंड टाइम फिर ऐसे ही लिए आपका हायर एजुकेशन का, वहाँ का भी उनको लीम का बुक ऑफ रिकॉर्ड में उनका नाम दर्ज हो गया। वो डीएन पटेल पूरा भागे भागे आई, हम लोगों को ये किया, मुझे ऐसे करते रहो, क्योंकि उन लोगों को इतने साल गुनाह किया है कि नहीं किया है, ट्रायल पे अभी तक है। मैंने बोली ABCD कुछ करो, A20 ऐसे कैटेगराइज करो, उनका ख़त्म करो। ये सरकार के ऊपर ये बोझा बनते हैं। हम उनको ये तो अभी तो ह्यूमन राइट्स भी है, आके उनको हम स्किल्ड करा सकते हैं। बाहर भी वो आना नहीं चाहते, क्योंकि बाहर आके समाज उनको बुरा मानेगा। इसीलिए मैं इस चीज़ को आपके ऊपर छोड़ रही हूँ, क्योंकि ये क्यों नहीं जाते हैं गांव के लोग छुड़ाने के लिए। बहुत सारे लोग क्या क्या करते हैं पता नहीं, जिंदगी ही ख़त्म कर देते हैं, लेकिन बाहर में घूमते हैं। इसके लिए आपके ऊपर मैं छोड़ती हूँ, क्योंकि ये जो 3 जो स्तंभ है, 3 जो विंग है, लेजिस्लेचर, एग्जीक्यूटिव और जुडिशियरी, कहीं कहीं जनसाधारण के लिए, देश के लिए, लोगों के लिए, तो कहीं कहीं सबका मन, सबका सोच एक होना चाहिए। चेक एंड बैलेंस तो होना चाहिए, लेकिन कहीं कहीं हम लोगों को एक साथ मिलकर काम करना चाहिए। जैसे जैसे लोग पहले तो गांव में हर चीज़ ख़त्म होता था, बहुत सारे चीज़ें जी, बहुत सारे सोसाइटीज़ है, बहुत सारी चीज़ें गांव में ही ख़त्म हो रहा है। आज छोटी छोटी बात में लोग जाते हैं, उसको कुछ किया जा सकता है, बैठ के बात करना है। और उसको मुझे लगता है लोगों को, हम लोगों के लिए है, लोगों के द्वारा है, इसीलिए लोगों के लिए सोचना हम लोगों का काम है। आप लोग सब यहाँ जो बैठे हैं, बहुत अनुभवी, बहुत ज्ञानी गुणी जजेस बैठे हैं, आपको सोचना है, हम सबको एक रास्ता निकालना है। कि कहते हैं आजकल तो और ज़्यादा जेल, बहुत सारे इतने ओवर क्राउडेड हो गए, और सारा बहुत सारे प्रिजन बनाना होगा। अरे हम ये आगे जा रहे हैं, हम विकास की ओर जा रहे हैं, फिर और ज़्यादा जेलें बनाने का ये क्या ज़रूरत है? कम करना चाहिए। मैं सब आपके ऊपर छोड़ रही हूँ। यहाँ लॉ मिनिस्टर है, और आप सब जो जैसे, मैं अपने बात को अधूरा रखी, बाकी जो नहीं बोल रही हूँ वो चीज़ को आप समझिए।
I have heard this kind of speech from the President of India for the first time when she was speaking from her heart. And I think the today's topic, what all point we want to cover, she has already covered. Executive, legislature, and judiciary, there are certain issues when they have to forget what are the constitutional duties assigned to them. They have to work in tandem, they have to work together to do justice, social, economic, and political, to the weaker sections of the society, and to see that the laws passed by the parliament for these sections are administered the way the parliament has intended and to be implemented. The most important sentence in her speech was कि मैंने बहुत कुछ कहा लेकिन बहुत कुछ नहीं कहा, जो मैंने नहीं कहा वो आपको समझना चाहिए. I think the future of our country lies in your land. And when we are talking of the contemporary issues which we are facing today, I mean, discrimination is still continuing. People of the scheduled caste, scheduled tribe community and weaker section of the society are still being tortured in certain areas. Dowry deaths are still taking place. Corruption is at the highest level. And these are all issues which, in spite of the fact that the laws are there, are not being addressed, or even if they are being addressed, the result of them are not being seen by the man on the ground. Mahatma Gandhi has said, whatever I'm trying to do or the government is doing, it must see how it is going to affect the last man in the society. If it is benefiting him, I should do it. Are we passing over laws? Are we passing over legislations keeping that spirit in view? I personally feel, because I have been at the helm of the affair when drafting legislations in the ministry for 25 years, there is nothing wrong with the laws. I think the wrong is with the implementation of the law. Those who are responsible for implementing these kind of legislation, the social and economic legislations, how true they are to their job to implement their legislation. I think that is what we have to see. And this is what Dr. B.R. Ambedkar, when the Constitution was being adopted in his constitutional debate, has said. Whether Constitution is good or bad is not important. Important is the people who are responsible for its implementation and interpretation, how responsible they are and how they interpret this particular Constitution to uplift the socially and economically weaker section of the society. That is more important. And I think if we are working in that direction, probably the kind of issues which we are facing today probably can be sorted out. Now, I share another example with you, two small examples. I'm sorry I'm exceeding my time because of this video which was shown. But two instances I will share with it because we are talking of contemporary issues is being faced by everybody. And the President of India has also spoken. When I was working as a secretary, our complaint was received from Tihar jail, signed on behalf of about 400 under trials, under trials, saying that they are in jail for 4 years, 5 years, or 6 years. Some of them have been granted bail, but they are not being released because they are not in a position to furnish the personal bond. At that time, Mr. Sadanand Gowda, who was the former Chief Minister of Karnataka, he was the law minister, and he called me. He said, Mr. Malhotra, can we do something about it? This is a representation which we have received. He said, don't tell me, because as a normal procedure, as a bureaucrat, what I would have said, I said, granting bail or not granting bail, Criminal Justice Administration, this is the subject matter of Home Ministry, send it to the Home Minister, let the Home Ministry take a call on this. But he said, I don't want this answer. What is the solution available? Then I suggested him, let's go to the National Legal Service Authority, which is supposed to provide legal aid to the persons who are in prison. And in case there are genuine cases, probably legal aid authority has got certain consuls who are working for them. Let them go to the jail, visit the jail, meet these people, and wherever there are genuine cases, move an application asking the judge that without insisting for bond or surety, they should be released. And I tell you, the impact was within 6 months, out of 500, 300 under trial prisoners were released from the jail. So I think if some positive steps are taken in implementation, there is no deficiency in law. Problem is only with regard to its implementation. I remember when this case, Nirbhaya case happened in Delhi. The Criminal Law Amendment Bill Act was being passed, and I was the one who was responsible for its drafting. It was being drafted under my direction because I was the secretary there, and we had a whole team of 25 officers. We had Justice Verma Committee report also for its implementation. Law has been passed. The definition has been changed. The scope has been increased. But when it comes to implementation and the provision of the implementation of the provision of that there should be day-to-day trial and the trial must be completed within 6 months, that is not happening. So what is wrong? Wrong is with the implementation part, and I think that need to be corrected. And I expect that when we are celebrating this Azadi Ka Amrit Mahotsav, and in the next 25 years, most of you who will be adorning the chair of a judge or working as an advocate, please ensure that this kind of injustice which is being meted out to the lower section of the society, they get full justice from the hands of the court. Technology is doing wonders. Only problem is probably law is not keeping pace with the developing technology. What we need to do is, as a judges or as enlightened member of the society, that we should interpret the law in such a fashion that it is subserve the cause of the common man. If we are able to do that, probably the job for which we are sitting here, that will be well served. Most of the issues and the alternative is, you can say that there is a dearth of judges, and President herself has said, अरे आप जेल बढ़ा रहे हैं किस लिए और लोगों को prison में डालना है क्या? There is no need to increase the judges. See that the lesser crime is committed. There are lesser crimes, and the prosecution, whatever is happening, that is done as expeditiously as possible. If that happens, probably the objective can be achieved and technology can be used. To some extent, it is being done. Artificial intelligence also being used in delivery of justice. So development is taking place, but it is not keeping pace with the time and with the requirement of the society. And you as a student, as part of, and you are all people blessed, when we were doing our law, probably this kind of symposium or interaction was not there. You are lucky that you are having interaction with people who have spent their whole life dealing with this kind of situation. We were not getting that kind of opportunity. So you are blessed, and the kind of guidance or advice or the experience which we share with you, take advantage of that and start doing right now. Not necessarily that you should wait only when you become a lawyer. As a research associate also, as an intern also, you can go to the law firm and can help. I have already exceeded my time. There may be many questions. I'll be happy to answer those questions, but I want to leave time for the other dignitaries on the dais, so I will not discuss the other topics in case of need. Other points I'll discuss a little later. Thank you very much for your attention, and thanks to the university for giving me this opportunity to come here and share my thoughts with you. Thank you, Dr. Sura.
Thank you, sir. Thank you so much for such a thought-provoking speech. Ladies and gentlemen, our next guest of honor for the session is Professor Shireen Musvi, eminent historian, dean and chairman, Center of Advanced Studies in History, Aligarh Muslim University. Professor Shireen Musvi has served for 44 years as a professor at the prestigious Aligarh Muslim University. Throughout her career, she has held important posts such as of the chairman of the Department of History and director, Center of Advanced Study in History, dean, Faculty of Social Sciences, director for Center for Women's Studies, to name a few. With a big round of applause, my friends, let us all welcome Professor Shireen Musvi, eminent historian, dean and chairman, Center of Advanced Studies in History, Aligarh Muslim University. I request ma'am to kindly address the gathering.
Thanks. Dignitaries on the dais, colleagues, and my young friends, to borrow a phrase from my hero in history, Jawaharlal Nehru, the hopes of tomorrow. And being the hopes of tomorrow, you must remember that it is not your future which depends upon you, but the future of our motherland, India, depends upon you. Of course, I come from the discipline of history, and certainly in a gathering of the faculty and students of law, I'm an odd person out. But it is at the instance of a former student of mine, all of whom I never say no for anything, that I am here. And I hope you will bear with me while I will not be talking law, but about history of our motherland. I'm talking about religion and law, the historical roots of secularism and its essence. I think you might be knowing that in today's India, my country of birth, the country of my forefathers' birth, nowadays the situation is rather precarious. In our childhood, religion was not the identity. Country was the identity, even the region was not the identity. We were all Indian, and we were all supposed to have one, what you will say, solidarity or affinity, and that was Mother India. Nowadays, the situation is a bit different, but I hope you will not be led away with these type of distinctions. So I'm talking about the historical roots of secularism and its essence. India has since ancient times a country of multiple religions. Rise of Buddhism, Jainism, Ajivikas, now extinct, in 6th century BC, all three of critical Brahmanism. They quarreled and called each other Pashandas, deceptors or frauds, so that Ashok around 250 BC used this term for all religions in his famous 12th Rock Edict, called the tolerance, generally called the Tolerance Edict. The very fact that Ashoka had to issue such an edict shows that religious tolerance was then not common. Kautilya in Arthashastra says followers of non-Brahmanical sects, Pashmandas, must not be allowed to live in cities. However, to foreigners like Al-Biruni, writing around 1035 AD, India appeared to be a country where no one killed one another on account of religion. And foreigners, even in Aurangzeb's time, that is 1659 to 1707, recorded their surprise as India so easily harboring different religions. Though, of course, Akbar's reign, 1556 to 1605, was a special period where not only religious amity, but also the cause of reason, aql, as against blind faith, manqul, was openly and strenuously pursued, alongside fullest tolerance. Good reason now for the UGC to exclude even the name of Akbar from the prescribed history syllabus for bachelor degree. The religious issues were certainly brought into focus when justifying action or against enemies, Muslims being malechhas to Hindus and Hindus being kafirs to Muslims. When Akbar followed his policy of inter-religious conciliation, a Jesuit priest, Father Montserrat, commented that Akbar did not realize that tolerating all religions was opposed to the principle of every religion. At that very time, Jews were burned to death in Portuguese Goa. After the British rule was established, a cautious religious policy was followed by open patronage of Christianity, which was held to be one of the causes of the mutiny of Great Rebellion of 1857, where all Indians, irrespective of caste or religion, gave their blood for the independence, and rather an unsuccessful attempt for the independence of country. But by this time, a theory of separation of state from religion in the name of secularism had already been initiated through the practice it defined and already come into vogue in the Atlantic world. Secularism as a mode of political thought originated in practice much before the term came into practice. The French Revolution of 1789 is the key seat of its birth. The French revolutionary leaders not only separated the state from the Catholic Church, but denied that religion, that means Christianity to them, could determine civil and criminal law, let alone influence the practice of the state. Thus, by 1794, women in France had obtained equal inheritance and property rights, and equal with men, and even compulsory school education was introduced for girls along with boys. The French revolutionaries even denied that they are Christians, though they tolerated practice of religion. Napoleon in Egypt in 1799 declared to the French forces, "We must tolerate Mohammedans in Egypt as we tolerate Christianity in France." Simultaneously, when the Bill of Rights was added to the US Constitution in 1792, it totally ignored any religion, even God was not mentioned, and freedom of conscience and speech was promised to all. Thus, US had already obtained a constitution free from any religious influence, mainly done in order to avoid Protestant Catholic controversy. The word secular itself was first used by British social philosopher G.H. Holyoake in 1896. Only in 1850, though he defined precisely in 1852, secularism by reference to Holyoake, the doctrine that morality should be based solely on regard to the well-being of mankind in the present life, to the exclusion of all considerations drawn from belief in God or in future state or afterlife. Holyoake based his term on Latin word seculum, meaning word, so in effect secularism meant excluding religion from affecting civil and criminal law of the state, and secular education meant excluding religious influence from education. All over the world, and in India till 1956, and so in view of the original draftsman of Constitution in 1951, secularism bore this meaning. But in 1956, S. Radhakrishnan, Vice President and then President of India, wrote in his Recovery of Faith that when India is said to be a secular state, it does not mean that we reject the reality of unseen spirit of the relevance of religion to life, or that we exalt irreligion. We hold that no religion should be given preferential status. This reduces secularism to a principle of equal treatment of all religions, which is the meaning given to it in India. While throughout the world it meant excluding religious influence of any kind from forming any formation of state policies and legislation. When in 1976 Parliament added the objectives of the making India secular through an amendment to the preamble of the Constitution, it is not clear if it had the international or the Radhakrishnan definition of secularism in mind. But unfortunately, the Supreme Court has given its sanction to Radhakrishnan's definition. And this has resulted in gravely distorting, if not destroying, the secular structure of Indian state. The destruction has come slowly. In 1984, the Shah Banu case, the Supreme Court could just have said that the criminal code whereby an abandoned wife can ask maintenance prevails over Muslim law as in punishment prescribed for theft, but it went on unnecessarily to hold that Muslim law too permits payment of monthly allowance to divorced wife. It was the latter claim of being better in reading Muslim law than the Muslim theologian that particularly aroused bitterness. But the concessions to the major religion of India, namely Hinduism, has been striking here. Here too, taking advantage of the Radhakrishnan definition, thus Article 28 drafted when Radhakrishnan's subversion of secularism was still 6 years away, prohibits entirely any religious instruction in government funded schools and prohibits religious instructions from being made compulsory for pupils of government-aided schools. Yet a 3-judge bench of the Supreme Court in 2004 invalidated the entire prohibition by making instructions in religion compulsory. It held that the religious instruction should not be confined to one religion only, but all religions should be taught in practice. Of course, this was hardly practicable. There being so many religions, the judgment simply meant that, that despite the constitution's expresses prohibition, free rein was given to include religion usually as in one's favored religion. Indeed, Supreme Court itself has taken steps which essentially violate the secular fabric. And while in the recent Babri Masjid case, it gave the judgment in favor of Hindu parties, it did not hand over the ground to those two parties, as Allahabad High Court has done, but asked the government of India to form a trust to build the temple. This was a serious blow to a secular fabric conceived in our constitution. In the present situation where hardly anyone now speaks of secularism, not even pseudo-secularism, the favorite critical phrase as 10 years or more ago, but only of religion and religious symbols. I have here spoken as a citizen and a lay person. It is for your jurists to find solution to the present conditions faced by our motherland. And I hope once you have completed your law course, you will be the luminaries who will bring back the Nehruvian concept of secularism back to this country for the furtherance of amity, unity, and progress of our shared motherland. Of course, no one came from outside, and if you say coming from outside means something, then Aryans also came from outside. Once we are born in this is country of our birth, and no one, howsoever he is capable or powerful, can deny it to us. Thank you very much for giving me time. Sorry if I have taken more than what was assigned to me.
Thank you, ma'am. Thank you so much for such an enthralling speech. Ladies and gentlemen, our next guest of honor for the session is Advocate Harish Kumar, Senior Partner, Luthra & Luthra Law Offices. He has had a career spanning for more than 2 decades in the field of corporate law. He first served as General Corporate with Singhania and Company, followed by various roles at firms like JP Group, DMD Advocates, Legal India, and Amarchand Mangaldas as well. This was followed by his current job as partner with the prestigious L&L Partners, formerly known as Luthra & Luthra. Apart from his busy career, he also does important volunteering work. He volunteers as Joint Secretary at Chamber of Tax Consultants, New Delhi, and is also serving as a member of Company Law and Governance Committee of PhD Chamber of Commerce. With a huge round of applause, my friends, let us all welcome Advocate Harish Mishra, Senior Partner, Luthra & Luthra Law Offices. I request Sir to kindly address the gathering.
Thank you very much for this. Thank you very much for this introduction. First of all, my heartfelt gratitude to the people out here, with a special thanks to the dignitaries on dais, and let me give me a special thanks to my dear Ayush Mishra, the professor here at WPU University, for this kind invitation. I think I'm the youngest one for the day, at least, to share my thought. And post lunch with this heavy, but I would say healthy food, difficult to, I think, to get to continue with kind of session. But the subject is so kind of I would say generic, but very critical, important one that anyone can speak for hours and hours, because the topic something like this, law and peace, in the context of the literature, illustration, expression, words, what we are sharing is just never ending. So I think I may have different words, different expressions, but I think crux remains the same, which the people have narrated, illustrated in many a manner. Before speaking on the topic, let me, I think, share my bit on what I always sort of expect, from the people when I interact. And I do a lot of interaction with my young team members, importantly interns within my organization. And I spend good amount of time with the interns. And I was a person who always wanted to be in the area of finance. I'm talking about 20 years back. So I always wanted to do some kind of good work in the context or in the business, management side, business side, importantly finance side. But somehow something clicked to me, and I shifted completely from finance towards legal. I'm a person with the finance, commerce background, but then the journey started, which is still going. And I really want to do something more, in fact, into the law field. So when I talk to my colleague, my youngster, I always say that, law is a paper. Okay, how it interacted. One day I met a person, interns, and when he asked him, why do you want to do internship? In fact, why did you opt for the law? His immediate response, I don't know whether it was pre-designed or he thought about it, but that really kind of, impressed me to a great extent. When I asked him, why did you opt for law? What he mentioned, that sir, law is the only profession, which gives me a right to fight for the causes of others. So which is so true, so apt, I would say, as on date. And what I feel that lawyer, again, this is purely based on my experience, what I feel the law profession, be it civil, criminal, for any cause, that remains the most dynamic profession as on date. Just to give a simple example, let's say today I have issued, and this has happened number of times. In fact, medical science is also settled to a great extent. Until we have this thing called COVID, coronavirus, we have sort of cure or protection or medicine to anything, everything generally. We know this is curable, this is not curable, it's stage 1, stage 2, but we have kind of, available medicines, guidance, measure. But law is something which keeps evolved on daily basis. So today I have issued an opinion, let's say, to a client on any given issue, and that he's going to file with the regulator or the court, or maybe a piece of opinion I have issued to the board of director, the senior management, basis that they want to take a call. But in the midnight, there is a circular interpretation, press release, etc. issued from any of the relevant governing body which would have, been cited in my opinion. That changes my entire opinion, 360 degree. And my opinion is of no value, 6 hours down the line. And that's how law works actually, So that's the reason I always say you have to be hungry, you have to be courageous, you have to be willing to learn, relearn, learn, and the cycle is ongoing. That's what I always kind of advise, and I have been kind of practicing it for last about 20 years, effectively for last 10 years plus. Because this is a process, this is a business in which you should first deserve. If you deserve, there is no need to demand. So that's a DD theory which I think you should be focusing on. I think we should rather be focusing on the inclusive growth rather than the monetary fund. Once you get a kind of this kind of work, kind of authenticity in your DNA, money is to follow. Don't follow, I would say, don't kind of follow the money, follow the work, follow the essence. There is and that's how we call it a kind of inclusive growth. There's a good saying which I always quote. They say that, fitur hota hai har umar mein juda. And this is how I define, a person, a human's life. Fitur hota hai har umar mein juda, khilona mashuka, rutba khuda. So you rather, focus on achieving the inclusive growth, and I would say sky is the limit. In fact, there would be, your success is limitless. That's what I can kind of, bet upon. Now, in the context of the subject for the day, let's say, peace, basically the social, cultural, legal issues. So let me cite you some live issues happening within the context of, current Indian economy. So there's a concept of, I would say, dual employment. So if you see post-COVID, during COVID, post-COVID, we have seen many people have left their jobs, right? There is a mass level layoff happening, not only from the international companies like Meta, like Facebook, like Twitter. In Indian context, we have, Baizu, we have Vedantu, we have Ola, we have Infosys, Wipro, who have actually done mass level kind of, layoff. And obviously, reason includes, slow growth. And one of the key factor, or I would say motivation, a considerable amount of motivation for the people who are either at a reduced salary or maybe have laid off or who are doing work from home is a kind of moonlighting concept, which you guys would have heard about it. moonlighting, or maybe we call it dual employment. So I think now we are in a stage of time when we have to think about whether or not, dual employment can be considered to be a kind of permitted mean of, employment within the legal parameter. Because now, 75%, it's a study, by the way, 75% employer have kind of assumed or have accepted the fact that this work from home is going to stay. Work from home is going to stay sort of permanently, particularly for certain industries, including IT and ancillary incidental. Now, you are working from home, you are an employee. I'm an employer, my employee is working from home. He or she is getting the work done properly, efficiently. But at the same time, my employee is feeling that I'm low paid, but I have a time and I can focus on some additional work. Should not I be allowed to act for, or for the additional employment? But yes, there are certain concerns, right, from the employee perspective, from the employer perspective. So one of the factors I would say from the employer would consider about the confidentiality. My data, my information should not be lost, should not be leaked, should not be shared. At the same time, the employer would come about that, I'm a person, I have signed the NDA, I have signed the kind of non-confidentiality agreement, I'm not going to do it. What I'm doing is in addition to the present state of work. This is Indian contract law, you guys would have heard about section 27. So 27, the crux of section 27 is that, any clause in your employment agreement which is in restraint of trade is void ab initio, right? So if you put a clause in the agreement which is an invariable clause that you are a whole-time employee of the company, you can't take up any other job including that of the consultant, that seems to be void as per the broad ambit of section 27. But I think this section 227 of the was written way back 1872. In my personal view, this section needs to be amended. This section needs to be reviewed in light of the kind of present economic state of affairs. In fact, of late, the courts, the judiciary have started sort of, issuing liberal, orders, judgment within the ambit of applicability or non-applicability of section 27. Because the business of the company, I'm a company into fintech business. My whole business stands on a model. And for that model, I have trained my CTO. I trained my chief human officer like anything. Forget about the time, efforts. In fact, the cost, humongous amount of money we have spent on this person who is running the show. But if this person with that particular idea, on which the fate of about 1,000 of employees are dependent upon, if that person going out and joining my competitor, my business is down. It's not about my business, it's about the family of 1,000 plus employees, right? So that kind of reasonableness is something which the judiciary has started looking up to. Now what they say that if there is an amount of sort of reasonableness and they are looking at pro-employer rather than pro-employee. So I'm sure, once you allow a person to be on a dual employment basis with certain do's, don't, there is a requirement, immediate need, I would say, which has to be kind of amended, which has to be so inserted under the relevant sections, relevant provisions of the applicable statute, something Income Tax Act. He is a dual employee, whether the concept of employee, employer, contract of service would need to be amended suitably under the Income Tax Act? Probably answer is yes. What kind of amendment we need to make within the PF Act, within the Gratuity Act? In any case, our labor legislation is being amended maybe in 6 months. 1 year down the line, you have the draft wage code in place. So what kind of provisions we have to provide it for? So I think these are the areas. Again, lawyers have a role to play not only with the employment, with the employer, but also with the government. So these are the areas you may focus on. Now, these again a concept of CSR, corporate social responsibility, read with SSE, social stock exchange. If you guys would have heard about it. So anyone would have interest into the finance side, capital market, he can actually explore it. If you talk about the SSE got its origin from the finance minister speech during 20, when she mentioned about how to expand the funding of social enterprises, which are the NGOs. Because if you talk about the, I think Dr. Moily mentioned about the Indian rating in the happiness index. So if you talk about the Indian rating, overall rating in the context of the USG, United Nations Sustainable Development Goals, we have achieved about 62.8 points out of 100, and our rating actually is 1-to-1, which actually has increased down, I would say, from 117 to 121 during last 4 years. You talk about, I'm talking about the avenues available. We are talking about, and we will be a 5 trillion company 3 years further down the line. How it will become reality? Money will come in. There will be a lot of M&A. Foreign direct investment is going to happen. Factories are going to be set up. Manufacturing, status is going to be up. Import, export, gift city, SEZ, all these things are going to happen. One of the significant contributors are the lawyers. You are going to represent the employer, maybe the investor, maybe the employee. You are the person who is going to kind of represent the company in a dispute scenario. Of late, I am seeing, in fact, so there is a concept of arbitration. We generally put arbitration as a mean of dispute resolution mean. Of late, obviously, there are benefit of arbitration. One of the reasons why we put in arbitration place, it's a speedy, process. Generally, we got it done faster as you compare with the court-driven process. But when I draft a contract, I think about, because of late arbitration has become costly, So it depends. If my contract, my transaction is low value transaction, no point of referring back to arbitration. Probably I will be putting in the court-driven process as a mean of resolution rather than arbitration. So these things, I think, all are the relevant factor which probably you guys may look into and look forward to. So I have a lot of stuff to discuss about, but my predecessor have mentioned at length on many aspects, but certain areas which probably you can touch upon, from the concept of the cultural, I would say CSR, social stock exchanges, crowdfunding. Then there's a concept of, I would say this, advising the government in the context of making necessary representations for various, legislations, including the modification which have a direct bearing on the social cultural issues. So that becomes quite critical. So with this, I think I need to conclude because time is up, but would be happy to answer any query which you can raise it. Thank you.
Thank you, sir. Thank you so much for your valuable words. The socio-legal and cultural issues in contemporary India, it's such an important topic. Of course, every individual would like to share a piece of mind on that. And of course, we, the faculty members at School of Law, would not be, we would not like to deprive ourselves of the opportunity. So as a representative, I shall request Professor Ayush Mishra, an alumnus of National Law University, Jodhpur, to kindly address the gathering. Can we have a huge round of applause for Professor Ayush Mishra? Over to you, sir.
Okay. Thank you, Chanika ma'am, and a very good evening to all my dear students, or I can say the attendees. Talking about the topics, that is socio-legal and cultural issues in contemporary India. So we have heard the opinion of the legal luminaries, the legal stalwarts, that is Prem Kumar Malhotra ji, Advocate Harish Kumar ji, and Professor Syreen Musvi ma'am. And I am the last one who is speaking on this topic, so the job for me is a bit difficult as well as a bit easy. That is, I can conclude the topic keeping in mind the wordings, keeping in mind the opinion given by the other legal stalwarts. So talking about this topic, socio-legal and cultural issues in contemporary India. So I am of the opinion that in our school days, in social study, we studied a very simple line that with change in time, the society changes. With change in time, the society changes. But in today's context, if I say, we find that there are various legislations, there are various laws which need to be repealed, or I can say need to be amended. So today I am here to speak on one of the social stigma or one of the social issue that everyone talks about the right of a female. But what about the right of a male? Everyone talks about the female rights, not the right of a male. So I'm not talking about the right of a male only from the perspective of legislations, only from the perspective of law, but right of a male in a society. So there are two aspects to it. The right of a male, that is, right of a male from the perspective of law and right of a male from the perspective of society. First, talking about right of a male from the perspective of society. So from the perspective of society, if I say, I am just giving you a very layman example. How many times in a society you find that a male complaining to their parents or to their elders or to their guardians that my wife is beating me in my house? Answer is very rarely. On the other hand, we find every now and then the case that a husband is beating wife. So let's give a thought that why the husband is not complaining but wife is complaining. The answer to this, when you give a thought, then what we can draw a conclusion that one of the reason might be, you may agree or you may not agree, one of the reason may be that अगर मैं ये चीज अपने एल्डर्स को कहूंगा तो वो क्या सोचेंगे कि ये अपनी वाइफ से मार खाता है, right? So that is the social stigma that is attached to this particular issue, though it is I'm speaking very light topic, I am discussing the light topic. You might think that it is very light, but when you go deep into it, then you will find it is not so easy to remove this stigma from the society. We find 99% cases of domestic violence reported is reported by a female. Approximately 1% of the domestic violence case is reported by male. Right? This is a social stigma which is attached. We, the student of law, I'm also including myself as a student of law along with you all. We, the student of law, has to take an initiative, because 5 years, 10 years down the line, someone might be working in judiciary or might be working in legislative or executive. So we have to take this responsibility that we should change our laws with the changing time and change in society. Now just give a thought that 10 years before or 15 years before, there was a very less cases in respect to violence against male. But why this cases started emerging in 21st century? The reason is westernization and globalization. Westernization and globalization. So if westernization and globalization is affecting our society to this extent, then why not the law should be amended or law should be modified or new law should be enacted in respect to or on the similar line of modernization and globalization or westernization. When we see our Domestic Violence Act of 2005, when we see our Domestic Violence Act of 2005, the very first statement is domestic violence against women. Domestic violence against women. So the Domestic Violence Act of 2005 is inclined towards a woman. Why cannot be it a gender neutral law? So this is the high time that rather than, same goes with section 354 capital A of IPC. That is molestation. That is molestation. Again, molestation, when you see the section 354A, it talks about molestation of a girl. Right? So it is a time, gone are the days when we were having the cases of Eve teasing. Now you find the cases of Adam's teasing as well. Now we find the cases of Adam's teasing as well. But what is the, if the cases like this is reported, what is the recourse that is available? So there are very less recourse that is available for a male as compared to female, right? Now, I'm just giving you a very simple example, a judgment which was passed by one of the High Court. So judgment was, so the fact of the case is, wife filed a case against her husband for divorce. Wife filed a case against husband for divorce. And what was the ground of divorce? The ground of divorce was cruelty. Case was filed. When the argument when the lawyers made the argument, lawyers said that the judge asked, which type of cruelty? So the counsel representing the wife said that wife has filed this case of divorce on the ground of cruelty because husband is not sharing the Wi-Fi password. Husband is not sharing the Wi-Fi password, therefore wife have filed a case against the husband for cruelty. Right? Now imagine a situation, the situation is vice versa. Imagine a situation, the situation is vice versa. Wife is not sharing the Wi-Fi password with her husband. Can husband file a case of divorce on the ground of cruelty? Right? So, again I repeat, this is my sincere appeal to all the upcoming legislators, the members of judiciary and the member of executives to please look into it. Our IPC is of 1860. We are in 21st century. So even in 1860, my great-grandfather was not alive. Or my great-grandfather was alive in 1860. Now I am the third. When we talk about the hereditary, I am on the third stage. I am also following the same law which my great-grandfather has followed. Is it right? According to me, it is no. Right? So, again, my sincere request, so in 5 years or 10 years down the line, you all will be on some good positions. You all will be having some power to deliberate on it, that the certain laws, I just discussed the one aspect of it. There are various aspects which can be covered when we talk about the outdated laws. And indirectly, that is affecting our society. So, have a look on these laws. You can initiate a deliberation on it, and you can be a change. So, with that, thank you so much. All the best. Take care.
Thank you, sir. Thank you so much. Youth voices are important because the decisions and policies made today will directly affect our future. And one of the ways of capturing the voice of the youth is through passing of the resolution. One of the unique features of the International Symposium on Law and Peace is that we get a resolution passed. So, in the next few minutes, we will have a resolution passed. I'll read out the resolution before you all, and you all will cast your vote by raising your hand. So, now I shall read the resolution before you. We, the participants of the second edition of International Symposium on Law and Peace, hereby affirm that we shall maintain the sanctity and integrity of the nation by respecting its tenets of being a sovereign, socialist, secular, democratic, and republic. We promise to respect every religion, language, and culture for a peaceful coexistence in society. We will not let any inauspicious forces stand in a way of unity and brotherhood. Now, in the next 30 seconds, you will cast your vote by raising your hand whether you agree with the resolution or not. The resolution is reflected on the screen as well. Decide your mind, and I'm sure whatever decision you take, it will be for the betterment of our future. Don't hesitate to express your minds. It's a promise to uphold the unity and integrity of the nation. Okay, and the votes are in, and as I can see, this resolution has been passed with 99% of the person who has voted over here. Thank you so much for wholeheartedly helping us in passing the resolution. And of course, when the resolution is passed, we have to keep one thing in mind: our future is secured. And I'm sure with all the young blood sitting right in front of me, our future is indeed secured. On that note, there are certain moments in life which we feel like capturing throughout. And this being such a moment, we'll just not let it pass. May I please request all the dignitaries to kindly come to the front of the stage with the folder in their hands so that a group photograph can be taken and this moment can be captured. May I please request Dr. Guru Prasad Rao sir, Director, School of Design, to kindly join the dignitaries. We are indeed witnessing a historic moment where all the noted dignitaries with the folder in their hands are proudly endorsing the second edition of International Symposium on Law and Peace. That definitely goes for a huge round of applause. Thank you so much. Now I shall request Dr. Guru Prasad Rao, Director, School of Design, MIT World Peace University, to render the vote of thanks. Over to you, sir.
Thank you, ma'am. I think we had a very fantastic lineup of experts gracing this second international symposium and on law and peace. The technical session being socio-legal cultural issues in contemporary India. I think India and the topic what we have are so important. It drew expert views from Prem Kumar Malhotra sir, who also got the president's address to the stage. Thank you, sir, for this. And I think the young generation getting this legal and social, cultural perspectives will help India to grow to be a modern, what I can say, country. And many countries have been thinking whether we should imprison, when we talk of prisons and all, should we imprison humans like animals? Or there is a different approach that is required, like a rehabilitation, you know. So probably he brought out a very important point for all of us to ponder. Thank you, sir, for that. We also had Ms. Shireen Musvi, ma'am, eminent historian, who talked about the secular fabric of India. I think world is looking at India as a very secular country, not only because of our constitution today, but also what was very intrinsic to our ethos. From probably 5,000 years. Probably India was the only country where we have the Shanti mantra, which says, Sarve janaha sukhinaha, sarve santu niramaya, sarvo bhadrani pashyanti, ma kaschit dukkha bhagbhavet. Yeah. Yeah. Correct. Correct. Very, very rightly said. Perfect. 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 Wonderful. Correct. Perfect.
Everyone to follow whatever one likes to.
Perfect. I think she said India was so tolerant all the time. We had people for and against, astikas and nastikas.
So, sir,
And
sir,
it
sorry to
tells
say, sir,
everything.
just 30 seconds.
Yeah.
So that's something I want to touch upon. So I hear, learn lot about God, religion. Let me share my bit, 10 seconds. So when I say God, I think God or religion, this Almighty is everywhere. The crux is that हर आत्मा में एक परमात्मा है. You yourself is the Rama, you yourself is the Ravana. And I always quote these two lines during Dashera when I say, किस किस रावण चिता जलाएं, किस किस रावण आग लगाएं, घर घर रावण, जन जन रावण, इतने राम कहाँ से लाएं. So you yourself is a Rama, you yourself is a Ravana. So you have to kill the Ravan inside, you have to move towards becoming Rama. Thank you, sir.
Wonderful, wonderful. Thank you. Thank you, Harish Kumar, sir, for these wonderful lines. I think he also raised one more important thing, the legal activism by our faculty, who also opened it up. It is for us to look at various things which are coming as a legacy of very old times, colonial times. It is maybe new times require new measures. Can we re-look at those? Also, he mentioned. I think this subject here, socio-legal, cultural, is something which is going to touch each one of us, right? And I think this dialogue will continue. And with this expert views, what we have today, we'll move on to the next day for yet another wonderful program. I would like to thank our Dr. Vishwanath Karat sir for his blessings. And also, I would like to thank organizing chair Lalit Basin and Mr. Rahul Karat sir. And we would like to thank Prem Kumar Malhotra sir for his wonderful wisdom words towards the subject. Ms. Soumya Hariharan, Shrimin Muswi Madam, Harish Kumar for their wonderful comments. We also had accepted invitation for this program from Advocate Savitri Pandeji, who could not be here today. And I think we also would like to thank all of you who have been so patient. And I think we missed the question answer here, probably, that will go. I would like to thank all of you and the staff, the security, the administration for holding this event so wonderfully. And the people who served food, the committees, various committees involved. And we are going to look forward to one more wonderful day discussing about this. Thank you.
Thank you, sir. Thank you so much. With that, we come to an end of this session. But of course, that does not give you the license to go out, because we are yet to finish with one more session, which is Youth to Youth Connect on climate change and law, wherein your friends will be expressing their mind on this particular topic. I request the dignitaries to kindly take the first row while we begin with our next session, climate change and law. On that note, I shall hand over the mic to Ms. Manvi Sharma.
The path towards attainment of peace is always full of hurdles. However, legal deliberations can act as an important scaffolding for the construction of a peaceful culture. The legal fraternity is